Good to have you here.
I'm Kaitlin, how are you?
Kaitlin, how are you?
Hi, nice to meet you.
Good to see you. All right. Well, Kaitlin, Bethany, thanks so much. Now that we've talked about the possibility space, one of the critical things in all of this is what's going to happen with intellectual property, what's going to happen with cybersecurity, and then, what are some of the things that are coming up? Because we're only at the beginning, I believe, we're only at the beginning of really thinking through what the legal implications are, and both for these environments, and then, as we saw before, what this is going to do to the practice of law. We'll leave that alone for any education. But as we codify and as we describe and model and the kind of things that Marty was just talking about, we are creating artifacts, we are creating descriptions, we are creating patents, we are creating all kinds of things about the way we describe the world. And of course, the law is one of the critical ways that we navigate that. So let's start off with this notion of IP rights. I mean, I think of it as a Turing reality, named after Alan Turing, the one who invented the idea of a programmable computer. As we describe the world more and more digitally, these IP rights come along. What are you seeing, and how can people protect it, whether they're interacting with a large language model or a process or a description?
Sure. We're getting these questions every day, for sure. And there's a lot of IP rights to be thinking about, right? There's the input, protecting the information that you're putting into a model. There's the output you're getting. Do you own that? How can you protect that? We have AI companies we represent. They're interested in their own development of models and who owns that, and what if we're using an underlying LLM and then just improving on top of that? How does that ownership work? So it kind of depends on which piece you're trying to figure out, and we're trying to tailor the advice to every particular use case. I think the most common thing, though, for everybody, even ourselves just using AI, is about the input and the output, right? And so this is where we are helping our clients navigate and say, I'm not just saying this because I'm a lawyer, read the legal terms that govern the tools. We try to be practical. We pride ourselves in being practical advisors here, and our clients, we represent a lot of startups, will come to us from time to time and say, we want to adopt Salesforce or Microsoft Office, or will you take a look at these terms? And we say, you don't really want to pay us to look at these. These are standard tools. They've been vetted. You're not going to have any trouble getting funded or acquired if you use these tools. With generative AI tools, it really is important because some of the terms will have confidentiality provisions protecting the information you're inputting and the output you're receiving. Some of them will say that they will not train on that information, but others don't say that. So you really need to understand for particular use cases, if I'm planning my trip to Portugal and want a vacation itinerary, I don't really care if I have those protections in place, but if I'm generating code that I'm going to put into my product, it's super important because it might actually blow trade secret protection if you don't have those protections in the contract. So it is one space where actually understanding what the terms of service say matters and can matter to the value of your company.
And so when I think about this, there's terms of service when I'm interacting and using it as a productivity tool, and then there's a whole nother category when I begin to think about embedding it or reselling it. It sounds like that's a very bright line in terms of considering IP rights.
Yeah, and it's just about the information you're putting in and what you're getting out. What do you want to do with that? Is it important to you that it be kept confidential and not be used to train a model that, say, your competitors could also leverage?
Yes, awesome. Kaitlin, if you want to say anything on that as well?
Yeah, so thank you first for having us. Beth is the co-chair of our AI practice and focuses on IP rights and data rights with respect to AI. And I spend my days thinking about AI security, AI governance, and risk management.
Yes.
So just given what we just heard in the preceding discussion, a lot of what I do is think about, like, God forbid, these sort of complex infrastructure models, processes get weaponized, right? Like, how do we prevent that?
Yes.
And so that's really comes down to thinking about what are the security implications of AI? How does it change the threat landscape? And when you think about that, so AI just broadly, expands the attack surface. There are new data sets, there's bulk data being stored, There are new systems and processes, integrations that need to be secured. And how do you do that? So that means invoking traditional best practices when it comes to security. But there are certain security best practices that may become ever more important, such as API security with all of the integrations, identity and access management. And then there are actual AI-specific risks. So you may have heard of OWASP. They did it's an organization that's sort of dedicated to software security, and they identified sort of the top 10 risks posed by LLMs. And those include, for example, you've probably heard of prompt injection.
Yes.
Where inputs could manipulate a model, and there's several other risks identified there's 9 other risks identified in that top 10. Yes. Supply chain risk is huge.
Yes.
So there's so many third-party dependencies now in that, depending on how a company is using AI, they may be very reliant on third-party models, and if those models are poisoned, then that's posing a direct risk to the company. So those are some of the examples of sort of what we think about in terms of AI security, and it requires particular attention to mitigating measures, including making sure that you're applying least privilege principles. Ongoing monitoring, so it's absolutely not a case of set it and forget it. It's something that is going to be fluid. Obviously, the technology is advancing at an unbelievable pace, and these models sort of shift. So we'll need to, continue monitoring the performance, and just staying on top of the threat landscape and educating the employee base is really important.
In both these areas, could you what's your sense of what's kind of settled law? And I know Clarence Thomas basically said, stare decisis what? No, anyway, recently, but what's kind of settled areas that people don't need to worry about? And when do they have to start really thinking about, using, you and others, to really do things? So I think you're talking about, for example, if I'm using ChatGPT Teams inside sounds like that's well established, just like any other cloud provision. As long as you live within the recommendations of that contract, you're okay. But if you're thinking, is that a fair way to think about it?
Yeah, it just comes down to the contractual terms in these cases, right?
And what are areas that are more kind of fluid now?
Yeah, there's a lot of fluid areas. So, one thing, going back to IP ownership in terms of, can you copyright something that's generated by AI, right, like the output? Can you patent an idea that is output from AI? Both the Copyright and the Patent Office in the US have said, no, AI cannot be an author. There needs to be a human author or inventor. But then they've said, at some point, if there's enough human involvement, kind of modifying, improving that output over time, then it does become copyrightable or patentable. And so we're trying to figure out where on the spectrum that actually could be the case. And in the meantime, telling our clients to try to rely heavily on trade secret protection and making sure those confidentiality protections are in place, because that is one more settled area of law right now.
Fascinating. And then in the threat landscape, I imagine things like a reasonable man or a reasonable person, is completely fluid in some of these areas.
Yeah, and I think AI has played a big role in that. And, pre sort of the generative AI explosion, you might say that, reasonable best practices when it comes to security, there are some settled concepts. And there are some standard-setting regulators, for example. The New York Department of Financial Services has a comprehensive cybersecurity regulation, and many other regulators followed suit. So they sort of set the standard in terms of the regulatory framework. But with AI, with generative AI coming into play, those reasonable best practices, while I think fundamentally they stand. There is an evolution because of the nuance required in implementing AI security. And then also the stance that many regulators are taking that their existing regulations still apply to AI, whether or not they reference AI. So the department, for example, the New York Department of Financial Services came out with guidance showing how they view AI risks to be encompassed within each component of their regulation and require their covered entities to take AI risk into account when certifying compliance with that regulation, for example.
Yes. And so as you look across this landscape of both IP and cybersecurity threat, what are the things that your customers are telling you they're the most worried about? And are they the right things to be worried about?
I mean, I'd say it spans across all of our business units, all of our practice areas. So the AI Accelerator that I chair, right, has almost 60 lawyers in it that have dedicated a portion of their practice to AI specifically. But, you know, we've got cybersecurity and AI governance, tech transactions on my side, but we've got privacy lawyers, regulatory lawyers. We have our litigators litigating some of the fair use copyright cases. You know, we have corporate lawyers that are representing AI companies and in financings and M&A and the like. So it really just depends. It's every day is a new thing. There's not a day that goes by that I'm not talking about AI, but what they're asking can vary. I'd say for my particular practice, you know, the use of AI to generate code is a big topic of discussion because, you know, originally there was fear underlying that question, being like, I'm afraid to use these tools. What do I need to know? Now I feel like it's evolved. There's still a fear there, but people are coming to us saying, I'm afraid if I don't use these tools, I'm going to fall so far behind. So now I need to know how to use them and what are the do's and don'ts. In addition to kind of reading the terms that we already talked about, there are certain kind of practices and policies and procedures you can put in place, code scans, filters you can use, things like that that can help mitigate risk in using AI and developing code. So we're talking to our clients a lot about that. And that kind of overlaps with your area as well.
And Beth, could you just, and this may be too complex a question to answer in a brief manner, is there kind of a frame for how folks should think about what the hyperscalers protect and don't protect in terms of indemnification on IP and things like that?
So there's not much protection in terms of indemnification. There's and the other thing I'd say is this is one case where you kind of pay for what you get. A lot of the providers have various different legal terms that govern depending on if you're just using an open API versus if you're paying for an enterprise version. Yeah. So it depends. But like Microsoft, for instance, has a Microsoft copyright commitment for certain enterprise customers. Yes. So if you've paid a certain amount, right, where you do get copyright infringement indemnification, which is certainly helpful. It is only of the unmodified output, so there are limitations around what they will indemnify you for, yes. But you can find offerings like that.
So it's really important to look at those contracts in terms of, you might be thinking you're getting a deal, but you're taking on risk you didn't otherwise expect to.
Right.
And then, Kaitlin, in terms of what are some of the things you're hearing about from customers, and are they worrying about the right things?
Yeah, just pulling from what Beth was just saying, there's tremendous competitive pressure for companies to implement AI and become more efficient. And so what we've seen is that clients are, they want to further the business goals, but they also just want to make sure they're not tripping any regulatory requirements. Mm-hmm. Taking on unnecessary risk where they could be, mitigating that risk in advance. So that's where sort of the governance and risk management comes into play. And given the parallels between cybersecurity programs and risk management frameworks, the parallels between those and the frameworks that are best practice for AI risk management, that's something we've devoted a lot of our practice to. And so you may have heard of NIST, for example. They came out with an AI risk management framework. They also have a cyber framework. And so a lot of what I help clients with is just getting their arms around governing AI. So the horse has left the barn. Like AI is being used one way or another. So it's just a matter of making sure that you not only have acceptable use policies, but also like actual processes in place to consider the AI tools that are being used or developed, assess the risks of those tools, put in place mitigating measures. And the only way to do that is to know what you're using. So mapping, AI tools, and then putting in a monitoring schedule and a committee, for example, to evaluate new use cases. So actually operationalizing AI implementation as well as AI security.
Yes. So it sounds like the policies and procedures are going to be a big part if you get into the thick of a problem or a defense or something like that, how you actually, we may not know all the different ways that, prompt injection might try to spoof the models and so forth, but we do have guidelines in terms of what's reasonable governance and reasonable care and things like that that are very important in this dynamic area, it sounds like.
Yes.
Yeah, and it also sounds like Goodwin as a firm has committed a lot to, this area, right, as 60 IPs and so forth. And
yeah, and we're seeing it in the larger transactions too, like the M&A deals now have reps and warranties around AI usage, and do you have a governance policy in place? So companies are now figuring out through even that M&A process that they need to have certain things in place just to pass diligence.
Well, that's wonderful. Well, I always think of lawyers like I think of doctors. When you want one, you want the best one. So please join me in thanking our panelists. Thank you so much.